Your attorney comes to you and tells you, listen, the defense has offered $1 million. And you turn around and say, I'm not settling this case for at least $5 million or maybe even $10 million. And your attorney comes back and says, where do you come up with that number? What do you think your case is really worth? You want to know what this is all about? Come join me for a walk through the neighborhood as I share with you exactly what this is all about. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. There are many instances where an injured patient will turn around after a settlement offer is obtained and now refuse to accept any settlement offer unless it is above X number of dollars. So in this scenario, an offer of $1 million has been made and the client turns around and says, I'm not settling for anything less than $5 million or $10 million. Now, if that happens, I will turn around and say, well, what do you base that upon? And now they're going to try and justify how they came up with $5 million or $10 million or $20 million. And the problem is that they won't be able to justify it. They're doing it based upon learned behavior. They think and they hear about cases all the time about people suing for millions and millions of dollars. They hear and read about verdicts that have come in for $50 million, $100 million. And now they think that their injuries are worth at least that much, if not more. So they don't have a true understanding of exactly what similar cases have gone for as far as settlement. They are not familiar with what verdicts have taken place with similar injuries, and importantly, what an appellate court has upheld for a similar injury type case. That is critically important because if you are now forced to go to trial and a jury comes back with a very substantial verdict, and now it goes up on appeal. You have to know, when I say you, your attorney has to know and has to understand what is the maximum amount that they could ever expect to achieve and obtain from an appellate court that turns around and says, no, we believe that this is the highest number for this type of injury in the state of New York, and there is no possible way you will ever get more. And that's critically important to know and understand when the defense makes a settlement offer. You see, the defense knows the law just like we do. They have done their research to understand what the value of your injuries are worth, and they will always try and save money and always try and lowball us because they want to save money, save the insurance company money. However, they know what the value is when the case goes up on appeal. We will have known this information as well from doing our research. But my client typically does not know the answers to those questions. Typically, they have a visceral gut reaction that turns around and says, you know what? I will not settle unless I get above this amount of money. And it's okay to have that opinion, but at least you have to justify to the attorney, to your attorney, why you believe that's true. And if your numbers, your valuation is significantly higher than what the appellate courts have upheld for similar injuries, then it doesn't matter what you believe in terms of settlement. Why? Because even if you were to go to trial, and even if you got a fantastic, remarkable verdict, the likelihood of you ever sustaining and upholding that outrageous verdict is virtually impossible, especially if the research shows that there is no similar case with that value in New York. So your attorney will have to have a conversation with you to explain why your rationale, why your thinking may be totally incorrect. And once that happens, now you will have to evaluate whether the defense's settlement offer is appropriate. And if it comes close to what you believe and what your attorney believes your injuries are truly worth. And then you will have to decide whether or not to make a counteroffer to continue that possible negotiation or to cut it off entirely and say, listen, that's unacceptable. We are going to trial. This is not adequate for this type of injury. So why do I share this quick information with you? I share it with you to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you are thinking about bringing a lawsuit, but have not done so because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.